So I'm going to start the discussion just by giving you some broad feedback, background, about where does this debate come from, what's been the background to the debate, and then also just note what is in the actual bill at the moment, and perhaps kind of finish up to kind of lead out in our conversation around what are some of the issues I think one needs to think about just generally when you are thinking about an oversight structure, right? So these are not specifically to the particular model that's on the table, but I think it gives us a little bit of a framework to engage with the model that's on the table at the moment. And then, of course, it's all about your input. Very, very at the broadest level, at the background, we all know, of course, that procurement as we know it today in South Africa, modern public procurement, really originated with this idea of a state tender board, which was very general across the world. It was a standard way of doing acquisitions by the state, where you had a single body that acquired on behalf of the state. And from there, mostly goods at the time were simply requisitioned to entities. And this was a very different model from the modern state, because you literally had a central body that did everything. It was both the regulatory body, it was in charge of the rules governing procurement, and it was the operational body, it was the actual buyer. And this was really kind of the basis for this went back to the 1968 State Tender Board Act, which incidentally is still on the statute books, a complete anachronism now. But this was the model. So you had very much a central buying entity, but also from a regulatory point of view, it was really, it controlled its own functions. And this then, of course, fundamentally changed in 2000 when the Public Finance Management Act was introduced, which completely revolutionized the way we do public finance and public finance management in this country. And then shortly after that, the Local Government Municipal Finance Management Act, extending that paradigm into the local government space. And what is quite important to note of the PFMA and the MFMA in our current context is that it involved a so-called double decentralization of the state tender board model, in the sense that it didn't only decentralize the actual buying function, the acquisition function, down to state to entity level. So under the PFMA and the MFMA, following a new public management paradigm, every entity acquires for itself, is really in control of its own finances, very importantly, also including procurement, SCM, with the accounting officer being the primary holder of power to actually acquire. But importantly, it wasn't just the operational function that was decentralized, that is the actual procurement. It was also the regulatory function. So by way of this notion of an SCM policy, we decentralized the rule-making role to a very significant extent in South Africa, so that under the PFMA and the MFMA, the paradigm is that every entity will also define its own set of rules, of course, within a paradigm set out under the Act, but the nitty-gritty, the detail, is to be determined at an entity level. And we've not really been particularly consistent in the terminology that we've used in our country in this regard. Sometimes we refer to it as the system, sometimes we refer to it as the policy. We've never really been particularly clear on what the relationship is between a policy and the system. Be that as it may, the notion is that at entity level, the detail will be determined in terms of how procurement will happen at the entity level. And that there's also degrees in terms of that decentralization function, especially the rulemaking function, in the sense that for some types of organs of state, there's much more freedom, much more flexibility in terms of formulating their own rules than in others. And one can almost view it as a continuum, with local government being the most prescribed in terms of the municipal finance, municipal supply chain management regulations, where in quite some detail, the content of the SCM policy and the SCM system that a local government must adopt is prescribed in the regulation. Then going to your government, national and provincial government departments, which are governed under the PFMA with the Treasury regulations, where there's a single regulation giving us some details supplemented by instructions, and then going all the way to state-owned entities, for example, that's got significant freedom because they're not bound by the Treasury regulation on procurement, even though they're bound by the PFMA. So they've got a lot of freedom in terms of what they want to put in their preferential procurement, in their procurement policy. And then the preferential part, I should also add, follows the same logic as we now know following the Agribusiness judgment last year, that the power to actually formulate the preferential part of an SCM policy, called the preferential procurement policy, sits with the entity, does not sit at the central level. And that is because of the PPPFA, the Preferential Procurement Policy Framework Act, very much in line with the PFMA and the MFMA, granting that power to the entity. And we've really, under this regime, retained just a very kind of light touch SCM office in National Treasury that's had some coordination function, but not really any standing in terms of explicit procurement law, really kind of just getting their powers from Treasury's general public finance management powers. And this has really been the background where this whole thing started. Now, we then started to see a major shift in this paradigm in terms of procurement. And it started with the establishment in 2013 of the Office of the Chief Procurement Officer, the OCPO, within National Treasury. And in the 2012 budget speech, the Minister of Finance announced government's plan to appoint a CPO. And then in 2013, in the budget speech, the minister basically announced the implementation of this plan, and the CPO was consequently appointed shortly after this budget speech. And as you also see from those budget speech statements, the office was then created inside National Treasury as just an operational unit within National Treasury. So it basically just functioned as a part of National Treasury. But it was still done completely within the PFMA and the MFMA paradigm of decentralized procurement. And that's always been there's always been a bit of a tension there, because the OCPO, while it's an operational organizational structure, does not have clearly set out powers within our procurement law regime. They fulfill functions that's ascribed to National Treasury in particular places. They step into the breach where, in many instances, we simply don't have rules, or we don't have an entity, and necessarily then the OCPO fulfills that function. But if you go to the law at the moment, you will nowhere find in the law an explicit reference to the OCPO or the CPO as a state functioning. And that's remained kind of a limitation on what this office can actually do in terms of coordination. Now, in academic and kind of, let's call it academic scholarly debate, around it, there's been quite some debate and disagreement on what the ideal design for this kind of structure should be within the South African system. So I have, in a report that I did for the OCPO shortly after it was established, I've argued in favor of the creation of an entity outside of a government department, quite specifically also then outside of National Treasury. And in this report, which is publicly available, I argued for the splitting of the operational and the regulatory functions at a central level, but the regulatory functions, that is the function of making the rules, providing oversight, creating a challenge mechanism assigned to an independent central procurement regulator that is accountable to Parliament, and that the operational functions at a central level. That's the actual procurement, for example, such as strategic procurement or transversal procurement, should remain within National Treasury. And this was basically based on an analysis of what is the current practice globally in terms of procurement regulation. But other scholars, most notably Ryan Brunette, Jonathan Claren, and some of the colleagues at PARI, have argued to the contrary in a position paper that they've put out in 2020 on state reform, one of which dealt with reforming the public procurement system in South Africa. They've argued quite strongly for the retention of both the regulatory and the operational functions within National Treasury, and arguing that the constitutional powers granted to National Treasury in terms of public finance would be an important base for the powers of this kind of oversight structure. So as you can see from these discussions, there are different views on what such a model should be. And then we had the draft bill in 2020. And in the draft bill, there was created this thing called the Public Procurement Regulator. Quite an interesting proposal, because when you look at the terminology, the use of the word regulator, it suggests that this is a freestanding or arm's length entity, arm's length to any department. But if you go and look at the detail, the substance contained in the 2020 draft bill, you will see that's not the case. It is really just an entity within National Treasury. So this was then proposed in the draft bill to be the national controlling entity with explicit powers. So the Public Procurement Regulator in the draft bill was situated within National Treasury. And I think it's worthwhile to just flag, and I'm not going to go through all of this in detail, just flag some of the powers that was granted to this entity, the regulator in the draft bill. Some of them quite extensive. So you would see, for example, it had the power to intervene by taking appropriate steps to address a serious or persistent material breach of the Act, so really to take steps in terms of enforcing that, but also, if you look at F there, reconsider decisions of institutions where necessary. So very importantly, this regulator under the draft bill had the power had a dispute resolution function. It formed part of the dispute resolution mechanism created under this bill, and it was explicitly given the power to override procuring entities, that is to step into the shoes of a procuring entity and take a decision on behalf of that entity. And then very importantly also, it had the power to issue binding instructions across the entire regime. Subsequent to the draft bill, we then had the Zondo Commission reports, which said a lot about procurement, as well as I'm sure everyone on this call is aware. For our purposes, most importantly, the Commission recommended then, in relation to procurement, the creation of what it called an anti-corruption authority or agency for South Africa, and it called it the Public Procurement Anti-Corruption Agency. And when we look at the comments of the Commission in support of this idea, of this recommendation, it's quite clear that the Commission is of the view that the current framework, the current structure is not working. And the Commission was clearly of the view that a part of state capture, the reasons that it could happen was because of an inadequate organizational structure. So we see that in a number of comments. You see the Commission saying, in the view of the Commission and for the reasons which follow, the appropriate starting point for any scheme of reform must include the establishment of a single, multifunctional, properly resourced and independent anti-corruption authority with a mandate to confront abuses inherent in the present system. So that's a very general remark in the context of procurement. So these quotes come from the part of the report dealing with SCM, with procurement. The Commission then goes on to say, it is a fundamental feature of the agency that it be independent. There has, however, been lengthy judicial debate on the question whether such independence can be achieved within a government department or by an entity under ministerial control. That debate requires careful consideration. The question is a simple one, but the answer is fundamental to the Commission's recommendations. Put bluntly, should supervision of the procurement system be located within a government department, but with assurances of full independence, or must it be located outside of government control? This is really the heart of the debate. The Commission then goes on to state its position, and it says South Africa requires an anti-corruption body free from political oversight and able to combat corruption with fresh and concentrated energy. Public trust will not otherwise be re-established in the procurement system. The ultimate responsibility for leading the fight against corruption in public procurement cannot be left to a government department or be subject to ministerial control. What is required are specialized oversight and monitoring authorities, which operate upon the basis that they are independent in the full and untrammeled sense, i.e. that they are subject only to the Constitution and the law. This also implies that the choice of officials who will lead and staff such bodies is not left in the discretion of government. Such appointments must be in accordance with the transparent procedure in a public process. So the Commission really states its view quite clearly on this debate. And then the Commission went further and actually commented on what at that time was the 2020 draft version of the procurement bill. The Commission said the Commission must make it clear that it does not seek to question the vital leadership role of National Treasury in the design and oversight of the public procurement system in general. The Commission endorses many of the proposals contained in the bill. This is now the 2020 bill, draft bill, which will serve to centralize and strengthen public procurement standards. Nonetheless, for the reasons already made clear, it is not appropriate that any government department be tasked to lead the fight against corruption in public procurement. The vulnerability of any government department to undue political interference remains and will always remain. And the answer to state capture does not lie in replicating the very same features that allowed state capture to succeed in the first place. So the Commission being very explicit about its view, and I think this is an important consideration as we look at the actual bill. So let's then briefly just flag what we now have in the bill. So as you know, the bill has now been tabled. It's B18 of 2023. And in the bill, there's a change, firstly, in terminology. So unlike the 2020 draft, the actual bill now talks about a Public Procurement Office, the PPO, wholly within National Treasury. The bill is very light on the institutional structure of this body. It basically just gives us in a single section 4, that there shall be such a body. And it then only states that in section 4.2, the head and officials of the Public Procurement Office must perform their functions in terms of this act impartially and without fear, favor, or prejudice. But the bill does not go on and give any further content to this obligation on the head of the Public Procurement Office or the officials. It doesn't give us any content in terms of how this impartiality, this seeming independence is going to be achieved. For example, absent from the bill, which is very common in many other statutes where you've got similar kind of structures, is any provisions dealing with the appointment procedure, for example, of the head, or the protection of the employment of this head. So how easily can this head be removed? And we know from experience, and this is exactly what the Zondo Commission is also referring to, that that is a crucial aspect of any regulatory regime where you create an oversight structure that you want to insulate from political interference, right? You want this function that section 4.2 also states. You want it to be impartial and to simply follow the law. But in order to achieve that, you need to create some organizational protections. And we find nothing like that in this particular bill. And it's quite puzzling how this is going to be achieved. So how is this head going to ensure that it can actually fulfill its functions impartially? without enjoying some security of tenure, without being appointed in an appropriate process. But also, of course, the converse, right? So it's not just about protecting this agency, but also ensuring that this head of this office is duly accountable. So who is to hold this head accountable? Through what mechanism, etc., etc. Nothing in the bill on that. And then if we turn to the powers of this office, we find them in section 5.1, some interesting changes from the 2020 draft, some things taken away, which I think is quite interesting, and I'll note one or two in a moment, but very similar to what we saw in the 2020 draft, quite general. I think the most important one, which we will see in a moment under 5.2, is the power to issue binding instructions. In 5.1, you see the functions of this body, the things that it must do in functional terms, and it's quite a long list of powers granted to this, or at least functions granted to this office under 5.1, but to a very large extent, it is basically the kind of functions that's currently being fulfilled by the OCPO, right? So this is basically giving a statutory footing to the OCPO. And then in 5.2, the bill gives us the powers of this entity, quite broad. So I think the most important one is 5.2a, where the bill grants the PPO the power to issue binding instructions as provided for in this Act and any other procurement matter for the effective implementation of this Act. So this is really now extending the power that the OCPO has been using under the PFMA at the moment, the Section 76 power, across the board. So under this bill, all entities will now be subject to binding instruction from this PPO, which is at least for local government, a very significant change from what's been the case before. And it retains an important feature of the current model of procurement regulation in South Africa, that is regulation by way of instruction. And then a number of further features as well. And then 5.2e, exercise other powers confirmed by this Act. And if you go through the rest of the Act, there's also a number of functions and powers granted to this body. I've just pulled out a few that I think are quite important to note. So it's got a number of enforcement functions, really enforcing the Act, the regulatory regime itself. So for example, under Section 15, it can prohibit certain practices. So it can, the PPO will be able to tell an institution, you cannot do this, and that will be binding. It can also debar. So under the bill, the PPO will be the body that takes the debarment decision, that is restricting suppliers from supplying to the state. But quite significantly, and in a quite a significant change from what we've got at the moment, the PPO will also have the power to reduce or revoke a debarment that it has issued, which is not currently possible. And it must maintain a register very much like it does at the moment. The PPO will also have an investigatory function. This is ostensibly a nod in the direction of dealing with fraud, corruption, other abuse of the procurement system. I think this is exactly where we will probably see most debate around alignment of the bill with the Zondo recommendations, because it seems to me that especially in this function, the bill is not implementing the recommendation of the Zondo Commission, and it'll be interesting to see what their conversations are around that. But there's a whole set of powers granted to the PPO in Section 50 and following around investigations, how it can investigate, enter premises, etc., and then take action when it finds abuse. Now, very importantly, in this part of its functions, its enforcement functions, is to note that under the bill, the entity, the PPO, does not have a role in dispute resolution. That's also a very significant change from the draft 2020 bill. So in the draft 2020, the regulator was one of the levels that dealt with disputes or complaints, reviews of actual procurement decisions. And the regulator had the power to basically overrule a procuring entity in terms of procurement decisions. That is no longer the case under the bill. That power has been completely removed, and the PPO will not play any role in dispute resolution. So it means that if there's a disgruntled bidder and it wants to challenge a decision by a procuring entity, the PPO will not form a part of that remedies regime or that dispute resolution mechanism. It will go to the tribunal now. And I think that's a very important change. It's also a change that I think plays into the question around independence. Because one of my biggest concerns with previous designs has been, how are we going to ensure trust in the dispute resolution mechanism if there's no independence? Because that is a fundamental characteristic of all dispute resolution mechanisms. Now that dispute resolution function has been removed. So I think that makes the independence issue, at least in terms of dispute resolution, a little bit less problematic for me. Then the PPO's got some operational functions, involvement in actual procurement, and I've just pulled some of those out. Under Section 18, it's got the power to determine standard bid documents across the entire system, and the power to create and maintain a database for prospective suppliers. So basically a statutory basis for the current CSD approach. And again, this will now be system-wide for all entities in the country. A very important, quite late addition to the bill, we didn't see this in any of the previous versions. It was really only added most recently, in the most recent versions, is the ICT functions that we now find in sections 24 and 25. And they're quite far-reaching, quite a big job being placed on the shoulders of the PPO. 24 says that the PPO must develop an information communication technology-based procurement system for all procurement, etc., etc. So there's now an obligation on the PPO to actually create an e-procurement system, which gives quite significant new statutory powers and basis for the digitization initiatives that's been going on within the OCPO for a number of years. And then Section 25 then deals also with an interim. So it tells us that during the development of this new e-procurement system, the office must determine requirements for digitization, automation, reporting, and innovations by way of ICTs at a lower level. So even in the interim, there's an obligation to shift South African procurement in the e-procurement direction. And I think this is quite notable, this function that the PPO will play. Still on operations, so there's a standstill period that's created under this bill, during which all challenges must be dealt with. And although the PPO doesn't play any role in dispute resolution as such, it does have the power to approve urgent procurement in a case where the standstill it would be contrary to public interest, right? So there's a power granted in Section 49 that under urgent circumstances, it is the PPO that can allow the procurement to proceed despite a challenge, so despite of the standstill. And then also in Section 57, we have a deviation provision. The deviation provision to me is not quite clear. I'm not sure whether this deviation is intended to talk to deviations as we know it at the moment, that is deviations from prescribed procurement procedures, which has really become a way of procuring, or whether this is more a deviation from the Act itself. I think one can read it either way. I've put it here just as an operational part, so really allowing a deviation from a prescribed procurement procedure that is kind of doing single source or whatever the case may be. But I guess we will have to wait and see what would be in the regulations before we would be able to interpret this section definitively. And then the office has got some transparency functions in terms of procurement information. So it must determine information access, procurement information access across the board, and it must determine the disclosure regime, what will be disclosed information-wise. Of course, this links very closely to the previous powers around digitization, because it is within the digital procurement paradigm that information will become very important, and the PPO will have the power to decide how this must happen. Okay, so what are some of the kind of questions or issues that I think one should really apply your mind when you think about this kind of thing? And as I've said, this is just very general issues one can apply to any model or any design of a procurement oversight structure. So just going to quickly flag all of these. So one should really ask, what is the purpose of the body that you are creating? What is it that you want it to do? And then based on that purpose, you must think about your institutional design. Who will be doing it? Where will they be placed? And very importantly, what will the funding model be like? Then what functions are you going to grant them to be able to fulfill this function, this purpose, and what powers would it need to be able to fulfill those functions? And then very importantly, what is the relationships going to be between this body and a whole host of other players within the procurement space? So other regulatory or oversight bodies, for example, the Competition Commission. So how do we see the what we now call the Public Procurement Office's role and function and powers vis-a-vis the Competition Commission's purpose, role and functions, powers in relation to procurement? Within the executive, what is the relationship between this office now as it's situated as part and parcel of the national executive with the rest of the national executive, that is other government departments, but also then provincial and local government executives? What is the relationship with procuring entities? And then what is the relation with other organs of state, right? Those that more on the margins of the traditional state, things like state-owned enterprises and other kinds of entities that might or will be subject to the new procurement regime, but that sit at an arm's length to central government. Also entities like the Chapter 9 institutions. What will be the relationship between this regulator and the Chapter 9 entities? Okay, so that is it that I wanted to say to kind of give background. It'll be good to get some input. Before we do, let me give you two quick ad breaks. Firstly, when the draft bill was in NETLAG, a number of experts were asked to assist NETLAG in processing the bill and their engagements. And this was this group was called the Joint Strategic Resource. And we've subsequently now put out just our reflections on that process and highlighting some of the key debates and some of the key issues that we think are important to bear in mind when we think about this reform. And this paper has literally just been published. You can find it on our website, also on PARI's website. So if you go to our website, africanprocurementlaw.org, on the homepage, you'll find on the left-hand side a link that will take you to the report. You can go and see what we are saying in terms of the development and some of the debates. And then finally, for those of you that's interested, this will obviously also be a hot topic of discussion at our upcoming conference in September. And there's the information on that. Okay, so that's it from me. I think let's open the floor and get some comments and input.
I just wanted to ask about the future of the PFME. Once this bill becomes an act, what will be the future of the PFMA? Are we going to see the PFMA being amended or reviewed in the near future? Thank you.
Yes. So under the Act, immediately, there's just a very, very slight amendment to the PFMA itself. So that single power that you find in the PFMA that basically places the obligation on an accounting officer or accounting authority to create the SCM system. It's in 38 and 51, depending on what type of entity you are. That will be repealed. That single line is removed because that is now in effect being replaced by this new bill. And then the power under the PFMA to issue instructions on procurement, the 76 power, will also be removed, because again, it is now being replaced by the power granted to this office in the bill. The rest of the PFMA itself remains untouched. But I mean, if you look at the PFMA itself, you'll know that there's, apart from those few sections, really nothing procurement specific in it. Within the broader procurement kind of, within the broader PFMA space, the biggest change will be that Regulation 16 capital A, which deals with procurement, will also disappear, and that's really the meat of it. So it will be replaced by this regime, but the rest of the PFMA will remain. And Lindiwe, I mean, in my mind, one of the key questions is whether this bill is wholly aligned to the paradigm of the PFMA, which is a decentralized paradigm. I've got some questions in my mind around it. But at the same time, the bill is quite light. There's not a lot of detail. So it may very well be that the bill in itself is wholly aligned to the PFMA, but the question will then only re-emerge at a later stage when we start to think about regulations under this bill. Because I do think that there's at least the potential that we may see inroads into the paradigm of decentralized public finance management control, which might be problematic. But that will then become an implementation question rather than a question of the bill itself. And just to complete that response, Lindiwe, for our colleagues from local government, I think you would be most interested, because the MFMA, in contrast to the PFMA, will be very, very significantly affected. So the whole of Chapter 11 will be removed and will now obviously be replaced by this bill when it becomes an act. And that's got very, very significant implications for local government. It is quite a significant change in how we've dealt with procurement at local government level, in terms at least of the governance arrangements. The big issue there is the fact that councils will be completely removed from the picture. So at the moment, under the MFMA, the council is the one that is really in control of the procurement system at the local level, right? So don't get me wrong, not the actual procurement, the system. That role is completely removed under this bill, because Chapter 11 will disappear, and of course, when Chapter 11 of the MFMA disappears, also the municipal supply chain management regulations will disappear. So on the MFMA level, there will be the biggest change. Curtly, I see your hand. Please go ahead.
Hi, Prof. Thanks for the presentation, Prof. Just coming in from the local government angle, the bill seems not to take into account that local government is not a structure or a creature of statute. It appears to me, and I'm just interested in your view, just to get your view on the Public Procurement Office. Now, I also noticed this change in terminology from regulator to office. Does that signify that this office is no longer, but much of the powers is retained, especially the power to issue binding instructions? What's your view on that? I'm of the view that depending on the nature of the binding instruction, if it goes to where it makes the final determination at the local government as to who should get the tender, then under those circumstances, that binding instructions is unconstitutional. So for me, because our courts over the years have made it quite clear that local government autonomy is protected, and that by virtue of regulation, you cannot usurp the powers of local government. And I'm of the view that the PPO, this office, its constitutional power, its regulatory power may be subjected to constitutional challenge, especially when it goes beyond regulation. So I'm not saying that local government cannot be regulated, but for me, it will be interesting to see what type of binding regulations this unit or this office issue pertaining to local government. And then just the second point, Prof, it also by looking at that they can issue binding regulations, and the fact that the bill also is aimed at repealing Chapter 11 of the MFMA, I think that's just going to bring a lot of complexity to local government, and municipalities already at the moment are struggling to comply with the various MFMA rules. And so this is just going to add, and it's just going to make the system much more complicated. And it will be interesting to see in the future how this play itself out in practice. Thanks, Prof.
Yes. Yeah, I mean, I think, you know, you put your finger on, I think, a major question under the bill. It was even bigger under the previous version. So the 2020 draft, really, one read it and one had the sense that kind of local government was almost forgotten when that thing was written. This one is better. There's clear lines in this one, but I think you're absolutely correct in raising the question whether this bill reflects the actual constitutional alignment of spheres of government in South Africa. When I read the bill, I also get the very distinct impression that the bill is written from a paradigm that there's national and provincial government, and local is the implementing agent of either national and provincial, and that is its function. And we all know that is not the constitutional design, right? Our courts have said that now many times. That's the old constitutional design, the pre-94 one. Post-94, as you correctly point out, our local government sector has been recognized as an independent, fully fledged sphere of government. And I also have some reservations around whether that paradigm is accurately reflected in the bill. I think there's a lot of questions to be asked about the autonomy of local government, especially local government finance. So I think that there are important questions. Perhaps just one or two more specific points there. So on the power of the PPO, one needs to just be quite careful. So the PPO itself will not be able to issue regulation. So the regulation making power sits squarely with the minister, and that's appropriate. That's as it should be. Yeah. So the minister will be able to make regulations, and that is really no different from what we've got at the moment under the MFMA, where the minister will also make regulations as the minister has done in terms of the municipal supply chain management regulations. So I think that power remains the same. What is different is this instruction power of the office, which will now also apply to local government. And you're quite correct in saying a lot in the end will depend on the implementation of that power, as opposed to the power itself. So one can, you know, one can say, look, there's probably nothing objectionable to the idea of having a national body like this with the power to issue some kind of binding instrument from time to time. I mean, I think in principle that it's not objectionable. However, the big question is, what are the parameters of that power? So how far can they go? Now, I think what's clear in this bill, and again, contrary to the previous one, is that this office will not be able to take decisions on actual procurement. So it will not be able to say, You cannot procure with X, you need to procure with Y, or you cannot award this tender, or it will not have that power. It seems to me that's an important shift from the previous version, the 2020 version, to this version. That function, I think, has been removed. So in my view, if the PPO were to try and use its instruction power to do that, I think it will be acting outside of the powers granted in this bill. Ideally, I would like it to be stated more clearly, but that is my interpretation. So I think it's a rulemaking power. It's less clear to me what this power to prohibit certain practices will entail, because I think there we might run into very significant problems. So take an example that's very current, the piggybacking mechanism. For years and years and years, especially at local government level, we've had a very clear idea of how this piggybacking mechanism works, right? This joining another entity's contract mechanism. And then overnight, a new interpretation was adopted by a number of oversight structures about how this mechanism should work, and suddenly changed the entire landscape about how we used joining as a mechanism in our procurement design, our procurement planning. And to this day, there remains significant contestation within our public sector on what is the appropriate, what is the correct interpretation of the relevant law. Now, if we were to take this bill and apply the powers granted in this bill to that scenario, I can see that the Public Procurement Office may take the view that this is how this mechanism should work, and you cannot use it in the following way, and then put out a prohibited practice instruction. And that would be a very significant interference in the actual operations of bodies. And to me, I just don't know whether that would be an acceptable alignment of powers within our system. It might be, it might not be, but I certainly share your concern. I think, Charmaine, shall we go to the next poll? So let's end this poll. Quite a clear preference. So we've had 70% people participate, 54% of people said that they prefer a regulator outside of National Treasury as their preferred structure. And then the remaining respondents were split between a regulator and an office in National Treasury. So it's quite interesting because it seems that just in this group, we are almost equally split between whether we want it inside or outside of National Treasury, which I think is very interesting because it also reflects the, I think, general debate in terms of how to situate it.
Actually wrote on the chat, but I wanted to get your opinion, Prof, with regards to the actual buying function being centralized in terms of the new bill. What is your opinion on that, and vis-a-vis what we received as feedback from the Zondo Commission? Thanks, yeah. Prof.
Yeah, so it's interesting. I see very little centralized power in terms of in the bill. There's been an interesting change from the version we saw last year and this version that's now been tabled around transversal contracting. So previously, in the previous versions we saw, there was in the regulation making power, there was a one of the topics that the minister was obliged to make regulations on was the circumstances under which participation in transversal contracting would have been mandatory. So that was a kind of a roundabout way of saying that you know, transversal contracting, centralized procurement would become mandatory under certain circumstances. That's disappeared, and it's been replaced by a note, and I must also now check, because I've not checked this in the actual tabled version to see whether it survived the last cut. Yes, it's still there. So if you go and look at section 18, which deals with actual procurement methods, it's the only section that really deals with procurement methods in the bill. You will see that the minister must prescribe the procurement methods, basically. That means the minister must make regulations around what procurement methods we are going to use. And then importantly, under 18.2, it says the types of procurement methods to be prescribed must include, but are not limited to, transversal term contracting and public-private partnerships. And then it goes on to say the regulations for transversal term contracting must determine a process for identifying what is to be procured through transversal term contracts, and when a procuring institution must participate in transversal term contracting. So the bill clearly anticipates that transversal term contracting, centralized procurement, will be a feature of a new regime, ostensibly to be done by the PPO. It's not explicit, but I mean, that is, I think, implicit in terms of who's going to do it. And importantly, that such transversal term contracting is going to be mandatory, that there are going to be circumstances under which participation in a central contract will be mandatory. And again, I think that's one of the areas where I see a lot of tension between the PFMA and the MFMA on the one hand and this bill on the other. Because if we are going to see now a implementation scenario where large sections of procurement is going to be centralized, going to be transversal, and under this statute, accounting officers got no choice, they must participate. To what extent can we then still claim under the PFMA and the MFMA that accounting officers or accounting authorities are in control of their own public finance? Well, they're not, right? We know that procurement is the single biggest spent item on our budget. And that's got implications for the entire system and the design, especially also the accountability. So I've got some reservations about mandatory transversal contracting, but I think that's where the powers are situated. We'll have to see how that plays out. Advocate Nadipa, please go ahead.
Prof, and thanks for the presentation. Mine is a structural one, Prof, that requires consideration whilst we are at build stage. The interface between dealing with the source of the challenge that we have, because the source of the challenge that we have is precisely because we have a mandate that is transversal, and the transversality of the mandate is not forcing the actual policy holders to work together. So my question is, the interface of National Treasury and DTI's mandate in ensuring economic participation, what's your view in the light of, and I know the bill will not be talking about that, but what's your view in terms of how that can be dealt with generally in the contents of the bill, to ensure then that when the regulation comes, it begins to amend. I believe it's not the PFMA only that must be amended. Somewhere there's an amendment that must take place to make sure that the intent of this bill, when promulgated, is effective without hurdles. I have in mind some of the amendments that were done within the same procurement space from the competition side, in terms of renewable energy, in terms of research. That's why I'm asking this question. Because if these things are not considered now, we are bound to come back to the same problem. So I would want you to comment on that, and also for us to look at it in terms of the conference that we are going to, so that we can have very strong propositions there. Because I believe some of the things can be managed through a bill Because if it is in a bill, it's easy. I'll give an example in terms of the cybersecurity. Cybersecurity, there was there a section that was talking about your sets. It was talking about the cyber command, cyber this, cyber this. It was in the bill. And the institutions affected began to start doing the work. That is the basis why I'm asking this question.
Yeah, absolutely. I mean, you're spot on. I mean, I can think of half a dozen kind of areas that would be implicated in that, right? So think about land transport. Under the Land Transport Act, there's a whole set of regulations dealing with land transport. And all of that is dealt, within transport. And I've got major questions in my mind about, okay, so how is that going to be dealt with now under this thing? And that's just existing schemes. I mean, one of the things that I've been wanting to do, but I've just not had time, is to sit down with this bill and the NHI bill, the National Health Insurance, because I mean, National Health Insurance is going to rely very extensively on procurement. It's probably going to become, if National Health Insurance becomes a reality in South Africa, at the scale that it is contemplated in the bill and in the policy documents, it's probably going to be one of our biggest procurement areas. And the question is, how is that going to align with this regime? Exactly what are the relationships going to be? And it comes a little bit back also to the question we just had around transversal contracting, right? So if we conceptualize National Health Insurance as one massive transversal contracting scheme, who is going to be fundamentally in charge of that? Surely we cannot be designing a system where we fall back on exemptions, where we say, okay, well, there's this one area that let's just exempt it, because that exemption power is in the bill. The minister can exempt. But I mean, surely that's not a good way of dealing with it. And as you say, there are many different areas where we can see these linkages between general procurement regulation and a sector-specific mandate and policy area, where we have to really very carefully sit down and think about the relationship. And then we've not even started, as you also point out, and yes, you've just said in the chat as well, those other kind of general mandates, so not even sector-specific mandates, but general mandates, like competition, for example, or mandates within the justice cluster. I think this is, again, where we're going to come back to Zondo, right? So are we going to deal with procurement in a distinct manner under this regime, and hence exclude the corruption element in procurement from whatever new architecture we put in place to deal with corruption generally under our justice cluster? Or are we going to align these two things? Or are they going to be the same? We don't know. DTIC, I think, is again a prime example. There are many strands to DTIC that is just not clear to me. What is the alignment? So competition is one, but industrial development is another, economic development. Then going to another area completely, small business development. Where's the small business development dimension here? I see very little in this bill talking to the linkage with environmental protection, right? So how is environmental protection going to be aligned here? I mean, we're living in a time where we on a daily basis see the impact of climate change. So how are we going to be responsible in terms of our procurement function and sustainability? And that requires linkage between this regime and a whole host of other regimes aimed at dealing with climate change. So, I mean, you're absolutely right. And this is why I am I'm concerned that we might be rushing something now that we should not be rushing. But I say that with great hesitation, because it's also not as if it's not urgent that we get this thing sorted, right? We can't, the current system is just not working. I don't think it's any secret. So we need to get something in place, but you know, it is an extremely complicated picture and one would, I think one would want to see a clear sense of the kind of networking paradigm that I think is the only way to approach procurement in a way that it can work, being implemented here. And I think that comes really back to your comment around when we start to implement, right? So when we start to now create the detailed regime in regulations, for example, what is the paradigm that's going to guide us in understanding the relationships between what will be done under this bill and by the actors authorized under this bill vis-a-vis other regimes? And I don't see the organizational architecture here that immediately to me answers that question. It might be that one can develop it, but I would have preferred to see a clear organizational architecture in a bill like this one, giving us a very clear indication of how is this going to play out. Because let's just remind ourselves of agribusiness and the very difficult position we find ourselves at the moment in terms of preferential procurement. And the reason for that is simply because the PPPFA itself is not clear, right? It's not clear in setting up the relationships between different entities in the preferential space. And we shouldn't be making the same mistake again. That's my view. Michelle van der Berg, please go ahead.
Good morning, Professor. Good morning, everybody. I hope you are well, and thank you so much for allowing me to ask my question. Professor, my question is, to what extent do the new preferential procurement regulations align with the provisions outlined in the new Public Procurement Bill? And secondly, how do they collectively work toward promoting opportunities for historically disadvantaged individuals and business in government procurement? Thank you very much, Professor.
Thanks for that. Okay, so it's actually, it's easy to answer. Not at all. There's no alignment whatsoever, and there's also no alignment intended, right? Because what will happen is that this bill will completely repeal the Preferential Procurement Policy Framework Act, and with it, the new regulations, the 22 regulations, and it will completely replace that regime with a new one. So, so we are essentially completely walking away from the 80-20-90-10 kind of preferential scheme that we've now had since 2000, and we are going to see a completely new regime. Some of the elements will be the same in the sense that the bill still provides for preferencing, that there must be some type of preferencing. It gives us some of the categories that will be very similar from what we have seen under the PPPFA over time, but the detail, there's no necessary alignment between the current detail and the detail that we will eventually see under this bill. And I pertinently use the word eventually because the bill is, again, very, very light on what that regime will actually look like. It basically kicks that can down the road, and it tells us that there will be this preferential procurement regime. Not altogether clear exactly who's got the power. I think this is also one of the weaknesses of the bill. I think we are again setting ourselves up for another agribusiness. I, for one, at least, would like the bill to be amended to make it patently clear who's got the power. I think it's fudged at the moment. But that again turns on major constitutional questions around how do we read Section 217, and I know that there are differences of view, but I think Parliament should just take a stance. I think just because there are differences of view shouldn't lead us to fudge it. I think that's the worst outcome. So that's that. And then the bill, when you look at Section 17, Chapter 4, it gives some guidance a very broad kind of framework, if you like, around what should be included in that preferential regime going forward. What is quite notable is that it tells us that there will be set-asides. So I think that's a major shift, because we've not had clarity in our system about whether set-asides or reservations, if you like, is actually an acceptable procedure under our regime. And I think the bill tries to clarify that. But of course, there will be contestation. I can tell you now that that's going to be a very unpopular section. Right, ladies and gentlemen, we need to bring it to a close. I've got another call to join in 4 minutes, so I'm going to give Advocate Ndipa the last word, and then we'll wrap it up. In the meantime,
Prof, a quick one.
Sure, go ahead.
We have a session that is coming, and I just want to ask you, probably you might not respond now, but what has been your thinking in terms of utilizing that space that you've created to provide inputs,
Yes.
deliberate inputs on all these areas? I'm saying this, Prof, because procurement is at the heart of everything in South Africa. And if we don't do our part, we will have failed ourselves.
Yeah.
You're speaking about set-asides. I'll tell you now, when the military veterans mandate came to the fore, I was the first one to argue for set-asides. And it will be a sad day that now there's no understanding of a set-aside. But we need then to say, what does a set-aside imply, and how far does it go? And this was the unevenness in dealing with these policy organs of state that could have led to the confusion. And we don't have that opportunity now to claim unevenness. So my question is, would you want to share with us how you have structured it to deal with this, if time allows, of course?
Thank you very much. Yes, and thanks for that reminder. It's a good point to finish today's conversation. To remind everyone, if you've not signed up to join us on the 21st for our workshop in Johannesburg, please just drop me a line. We'll add you to the list. So we're having another national conversation in Joburg on the 21st, and we will absolutely be using the bill as the focus of that discussion. So what we will do is we will take those 5 streams that we identified in February, and we will zoom within those streams in on the particular aspects of the bill that we think require specific attention. And then our intent on the 21st will be to physically put down a number of points that we would want Parliament to consider. It might not be that we agree on the actual outcome, and that's not a problem. I mean, we can disagree. It's good to disagree. It means that we get different views on the table. But what we want to do is we want to draw up an input collectively that we can send to Parliament, to the committee, and say, look, as a community of practice, these are the things that we urgently think you need to apply your mind. These are the issues. These are the things that you need to think about. Here are potentially some options that you can think about. But at the very least, highlight exactly the kind of things that you are referring to, that we cannot let this opportunity pass us by. And that's what we want to achieve on the 21st. And of course, we won't be able to get to everything. It's just one day we've got together, but I think we can really do a good job in starting to put together some of those issues that we want Parliament to consider. And then we will also continue that engagement after the 21st offline again, as we've tried to do. But that is exactly what we're going to try and do. We're going to be trying and really put together some input that we can then forward to Parliament as just a collective input, right? This is just views but we want our public representatives to take into account. Okay, so let me close this session, and this is certainly not the last we're going to talk about the bill, right? So we will continue to engage with the bill. It's of course the biggest issue that's happening in our space, so I think it's good that we continue engagements and look at other aspects of the bill as well. Let me then finally say, if you quickly look at the second poll, based on your experience, how ready do you believe the current OCPO is to develop, implement, and achieve the aspirations expected of the procurement bill? And you would see that 24% said somewhat ready, but the vast majority, 73%, indicated not ready, to varying degrees, and that there will be quite a bit of changes necessary to deliver on the mandate in the bill. And I think that in itself will be an interesting conversation to see what from an organizational capacity perspective do we think are the changes that needs to happen, and perhaps start to put some of that on paper, and perhaps even in the bill, so that we can enable this new body to be able to do what it wants. Because the last thing we want to do is to create a structure that cannot deliver, that cannot give us the procurement system we want. So so with that in mind, ladies and gentlemen, thank you very much for joining me. So I've just been asked on the chat, the info for the session on the 21st. If you just go to our website, the same one you've got on the screen, but I'm going to type it in the chat as well, africanprocurementlaw.org. If you just go to our website, you will see on the landing page there's a block, a piece on the national conversation. Just click to the links and you will immediately get all the contact details, etc., to contact my office, to get the details, to get the invite. Please join us for that session. But before we meet on the 21st, we will have another session here. Thank you, everyone, for joining us for this session, and we will all speak soon again. Bye-bye.